Good afternoon and welcome to all. Thank you for joining us for the Legal State of the Nation with guest speaker Barb McQuade. This is the first installment of the 2021 Boston Speaker Series. I'm so glad you could join us from your home in the greater Boston area or really wherever you may find yourselves these days. My name is Ann Orloff and I have a great pleasure of knowing so many of you. I serve the university as executive director for the Eastern and Southern states for the Office of University Development. Before I introduce our host, let me share a couple housekeeping items. First, we've allowed a lot of time today for questions. Many of you have submitted them in advance, so thank you. But if you want to submit a question live, please do so via the Q&A window at the bottom of your screen. And second, you may use the chat function for comments and any technical needs. So now I'm honored and delighted to introduce Dennis Ross, our host and moderator for today's program. First and foremost, Dennis has 2 degrees from the University of Michigan, a bachelor's degree in English from our College of Literature, Science, and the Arts, and a JD from Michigan Law. Dennis is Executive Vice President and Head of Tax and Tax-Advantaged Investments for State Street Corporation. In this role, he manages tax and tax-advantaged investment functions globally and provides leadership on all tax-related matters. He also leads a team to develop strategies that support State Street's business and operating needs worldwide. Before State Street, he served as Chief Tax Officer and General Counsel at Ford Motor Company in Dearborn, Michigan. Prior to Ford, he was a partner specializing in tax at Davis, Polk & Wardwell, a leading Wall Street law firm. His impressive career also includes more than 5 years for the U.S. Treasury Department. Dennis is lucky to be joining us today from sunny Florida. So Dennis, thank you so much for being here. I'll hand it over to you to say a few words and introduce our guest speaker.
Dennis, you are on mute.
Apologies. Again, thank you for that introduction. It is my pleasure both to serve as moderator today and of this event, and to especially to introduce our featured speaker, Professor Barbara McQuade. Professor McQuade earned her law degree from Michigan in 1991, and after a clerkship with Judge Friedman of the Eastern District of Michigan, spent some time with the Butzel Long Firm in Detroit. But they then began a near 20-year term in the U.S. Attorney's Office in the Eastern District of Michigan. Initially as an assistant U.S. attorney, where she took on increasing responsibilities. But then in 2010, President Obama nominated her as U.S. attorney. And she served in that office until 2017, when she resigned after the change in administrations. And shortly after that, she joined the Michigan faculty. Well, Professor McQuade, the audience here is very eager to hear your take on things going on in the legal / political world. But I wonder if I might first ask you to just speak for a minute about your life at the law school. You're identified on the website as a professor in practice. And of course, your background is more in practice than in traditional academics. And I'm curious how that background has affected your life at the law school, your role at the law school.
Well, thank you, Dennis, and thank you, Ann, and thank you to all of our attendees from Boston. I was looking at the attendees list, and I see I have a number of friends, classmates there, so hello to all of you. Looking at you, Carla Brigham, but I'm glad they're all there. Dennis, in response to your question, one of the things the law school has tried to do in recent years is to diversify the faculty by hiring not only its traditional group of really high quality scholars, research professors, but to add to that group by hiring people who have been primarily practitioners. And so we have a handful of us who've worked in various parts of the law to bring a different perspective to class. And so I teach criminal law to first-year students. I teach criminal procedure to upperclassmen, and a course called National Security and Civil Liberties. I also teach in the problem-solving initiative. And one of the things I'm able to bring is, not only sharing what's in the case books, but also some real life experiences. I often share with my class pleadings in real cases that I worked on. I bring into the classroom frequently guest speakers, people I've worked with, judges or defense attorneys or civil rights advocates that I've had a chance to work with, and helping students see some of the nuance that exists in the practice of law. So I think in that way, I don't think we will ever replace the research scholars who do a lot of important teaching in terms of the theory of law, why we have laws, the evolution of laws, which is so important for law students to think about, to give them that foundation to go out and practice and take on the world and solve problems. But I think it enhances our faculty by adding a handful of us who have spent most of our work out in the trenches.
I might just note my son was in your criminal law course last year and is a big fan.
Thank you.
Oh, I'm sorry. Well, with that, please, as I say, the audience, I think, is very interested to hear your take on what's going on in the legal political worlds.
All right, well, thank you, Dennis. I thought I would talk briefly because as Ann said, we want to spend most of our time engaging with the participants here and answering your questions. But I thought I would talk just briefly about a few things that have been in the news, in the law during the past year. One is the Black Lives Matter movement and criminal justice reform. Another is the challenge of dealing with COVID-19 and protecting civil liberties. And the other is domestic terrorism, addressing that threat while protecting our rights to free speech and free assembly. So just a few light topics to cover. But I think if there's a common thread among all of them, it is the importance and need for nuance. I think that we live in a world where the loudest and shrillest voices get heard. In social media certainly contributes to that because people want to share a message in a very short post in just a few limited characters. We have cable television where people tend to find like-minded speakers who are just kind of reinforcing our beliefs in the echo chamber of what we believe. And there's been a lack, I think, of nuance. So many of these issues cannot be neatly divided into black and white. There are far more shades of gray. And I think we need to think about those shades of gray as we develop law and policy to address them. And I think if we stop trying to engage in political infighting and blame each other and use these issues as a wedge to score political points, we can reach consensus on how we want to deal with them. Nobody's going to agree on everything, but I think we can find that we have far more in common than we have differences if we spend a little time looking for the nuance and focusing on the nuance. For example, with regard to criminal justice reform in the Black Lives Matter movement, I think you can have, people are fond of saying both and. I think it is true that we need law enforcement in this country. We need to fund police departments. I don't want to live in a world without police. I would not fare well in a world without police. Law is there to protect the more vulnerable members of our community from those with power. Those with physical power, financial power, political power would take advantage of those of us with less power unless there were laws and enforcement of those laws. So we need those things. But it is also true, I believe, that we have seen disparities in our criminal justice system and that minorities, particularly Black people, are imprisoned at a much higher rate than they represent proportionally in our population. We have seen harsher sentences in terms of mandatory minimum sentences. And we have seen more unarmed Black people die at the hands of police officers than are represented in the population, something at a 2-to-1 rate. And so can we solve these problems? Yes, if we stop taking sides. There is no law and order party. There is no party that hates the police. We need to work together to address these things. And I think it can be done if we are thoughtful about criminal justice reform. It needs lawyers, it needs policymakers, it needs people who are willing to make compromises on certain things. Nobody can have all of it or everything. But I think one of the things that we are seeing is political leaders who want to use these issues as wedge issues to score political points. And we need to get above that. We need to there's more access to information. We need to take advantage of it so that we can make thoughtful decisions about where we want to strike that balance. you also see that same sort of thing, at least here in Michigan, when it comes to the government's response to COVID-19. In Michigan, we had some of the more stringent laws in the country about stay-home orders following COVID-19. And as a result, it's actually been pretty successful in terms of containing the virus within Michigan and reducing deaths. But again, I think because people want to score political points, they have made arguments that any restriction on kids in schools or businesses or restaurants being closed is a violation of our civil liberties. And of course, you know, for those of you who went to Michigan Law School with me, and those of you who have spent time studying issues of First Amendment and Second Amendment rights, you'll know that none of these laws are absolute, that there has been case law. In fact, the oldest case on this topic comes out of Massachusetts, dealing with an epidemic in the early 1900s. I think it was for either smallpox or polio, but it was a requirement that people be vaccinated. And there were lawsuits that said that's a violation of my civil liberties. And the Supreme Court held, no, it's not. That when there is a rational basis for the government to take action that can be justified, then the government may do so. And public health is among the most significant reasons that a government can act. But can governments go too far? Sure. I mean, reasonable minds can disagree. I often tell my law students that, you know, figuring out what is at one end of the polar extreme, public safety, and at the other end of that spectrum, maybe individual liberty. We could have all of one and none of the other, but I don't think anybody wants that. I think most of us want to draw that line somewhere in between. And so, again, we saw, at least here in Michigan, a lot of political gamesmanship when it came to COVID-19 orders. We saw protesters at our state capitol and President Trump tweeting, "Liberate Michigan." I'm just really feeding into and fomenting that kind of us versus them mentality. In fact, it got so bad here in Michigan that there was a plot to kidnap our governor that has been alleged in an indictment because of their anger about her COVID-19 stay-at-home orders. You know, if you think about this in a nuanced way, I think you'd realize that no governor wants their state to suffer economically. That's not so good for reelection. And so I think, again, we need to look at nuance and not be taken in by those who would reduce the argument to a couple of words in a tweet. And then finally, domestic terrorism and what to do about it. This is a growing problem in our country. The US Department of Homeland Security, even during the Trump administration, has identified domestic terrorism as the top threat to public safety in the homeland. FBI Director Chris Wray has said that the most significant threat within that is groups based on racial identity and anti-government sentiment. It's a serious threat. And I know that there are concerns that if you are to take an aggressive stand against domestic terrorism, that might infringe our rights to free speech and our rights to free assembly. In fact, in his brief, President Trump's lawyers have argued that when he talked about going to the Capitol to fight and be strong, that he was simply exercising his First Amendment rights. And, you know, that's a debate that they'll have in the Senate during the trial. But certainly the law draws lines, and it is very nuanced. It is not 100% absolutely true that you can say whatever you want, whenever you want. I think most of us are familiar with the famous quote from Oliver Wendell Holmes that you can't yell fire in a crowded theater when there's not a fire. And there have been cases on where that line is drawn. There's a famous case called Brandenburg versus Ohio that says the line is drawn when a person is seeking to incite violence and it is likely that that violence will occur. And so certainly people can say what they want about COVID orders and the police and Black Lives Matter and all of these things. But when they call people to arms to attack a particular target, they have crossed that legal line. It requires some nuance and open minds. And so I'm hopeful that, as you know, sometimes I think that when we look at history, we think it's getting worse and it's only going to continue to get worse. But it doesn't have to. The life of social media and cable television has been very short in the history of our republic and in the history of the world. And so can we swing the pendulum back? I think we can, but we have to seize on the opportunity to appreciate and engage in nuance. So I'll end my remarks there so that we can maximize our time for questions.
Well, thanks very much, Barb. We do have a fair number of pre-submitted questions, and I think we'll get some live ones as we go on. But maybe starting a bit where you ended your remarks. Many in the audience are interested about the events of the Capitol on January 6th, which have been broadly characterized as an insurrection. The country has certainly a long history of political protests that have turned violent. But insurrection would seem to, put things in a very different category. I think most people probably think of an insurrection as, the Civil War. Is insurrection the right term for what occurred at the Capitol? And if so, is there a legal significance to that term?
Yes, there is a crime of inciting insurrection. It's a federal statute. And I think it is one that could fit here. It's the kind of statute that isn't charged frequently. And so it leads to a dearth of case law and not a lot of clarity around what it is. But I think what makes this attack different and why it might fit under the label of insurrection is this wasn't just a peaceful protest or even a protest turned violent that you might see in various places. What happened in Charlottesville was a protest that turned violent where there was a death. But I think what makes this one different and why both the insurrection statute and another one called seditious conspiracy could be appropriate. The seditious conspiracy statute has as an element seeking to obstruct by force the enforcement of any law or the execution of any law. On that day, on January 6th, we had our elected leaders certifying the election for President of the United States. And it appeared to be the goal of this group to stop that from happening because they did not want there to be a peaceful transfer of power according to the law and the 12th Amendment. And so I think for that reason, it is correct to call what happened there an insurrection. I think we're still sorting through all of the facts and evidence. I'm sure there were some people who were just sort of along for the ride and followed people in. And for those people, they may be charged with lesser crimes like, trespassing and entering a restricted area and those sorts of things. They may even say, I never saw a sign. I walked right behind the crowd and walked right in. And as those of you who've been to law school know, not only is actus reus a crime, a part of a crime, but mens rea. So there has to be a bad act and also a bad intent that you knew what you're doing was part of what is prohibited under the statute. And so we are still in the process of sorting that out. But for those who pre-planned and were set on entering the Capitol for the purpose of stopping that proceeding, I think that meets the definition of seditious conspiracy. And if there was anyone who it can be demonstrated had the intent to incite that action, I think that they could be charged with the crime of inciting insurrection. Some have said that's what President Trump was doing. I think you have to look at all of his acts and comments, not just those he made publicly that day, which I think contained a mix of things like urging people onto the Capitol, we're going to march down there and stop the steal, with things like he said, we're going to be peaceful. And I think the things that he said before, during, and after, even outside the public realm, would be important to look at to see whether he had the intent to incite and whether it was likely that that incitement would follow.
You view that, Laura McTaggart and others have asked whether Trump is exposed to criminal prosecution here. You view that as a close question, or how would you characterize it?
I think I'll say a couple of things about that. So one is, could he be charged criminally with inciting insurrection? I think if you look at all the things he said that day, you could probably make out probable cause. But before a prosecutor will charge a criminal case, they have to believe not just that they have probable cause, but that they have evidence sufficient to obtain and sustain a conviction. I think one defense that he would be likely to raise, because he has raised it in his impeachment brief, is that the First Amendment protects what he said that day. I'm not sure that would prevail because of that Brandenburg test, that if you are intending to incite, and it is likely that your words would incite violence, that crosses the legal line. I think the likelihood part is met. I think the closer question is whether he intended to incite. And as I said, because his remarks that day included a request to be peaceful, I think it might be difficult to make that out. I think it would be important to look at other evidence, though. What did he say privately to others before that? What did he tweet? What did he say during that attack? I know there have been some reports that he was gleeful while it was happening. If that's the case, then that could tend to support his intent that there be incitement. Ultimately, he asked them to stop, but not until something like 2 or 3 hours later. I think that's some evidence. So I think we don't have a complete picture of all of those things. I think a prosecutor would want to look at all of those things before they made that argument, because I do think there is a danger of charging a case like this if you don't have compelling evidence to prove guilt beyond a reasonable doubt. Politicians give fiery speeches all the time, and I don't think we want to chill fiery speeches. And so I think one would have to be convinced that the evidence here proved not just that he was trying to be fiery and encourage people to protest peacefully, but that he intended for them to breach the Capitol and stop this. I think we need to see more evidence before we can be satisfied that that's what happened here.
Yeah. Now, impeachment, of course, is different than a criminal trial, although it has a flavor of that. And incitement is, I believe, the theme of the articles of impeachment. How will the Senate approach that? I mean, if they concluded that, or if he is not in fact indicted, I guess maybe we won't know that. But if they conclude he couldn't be indicted and convicted criminally, is that going to affect the way they think about the impeachment issue?
No, it's really doesn't have anything to do, one doesn't have anything to do with the other. Although, because there is no real legal standard when it comes to impeachment, one of the things we see is that various senators will frame it however they want to. The last time President Trump was impeached, there were many people who made that argument that, well, this isn't a crime, therefore it can't be a high crime or misdemeanor. I think many scholars disagree with that approach and have said impeachment is for any kind of abuse of power. That's what it's used for. It may overlap with criminal statutes, but it doesn't necessarily. And I think that makes a lot of sense because at the time the Constitution was written, we didn't have these criminal statutes on the books. And yet there is the impeachment clause in the Constitution. And so what this article of impeachment alleges is not that a crime per se was committed, but that the president abused his power by refusing to acknowledge the results of the election. It includes that phone call he made with the Secretary of State of Georgia, where he urged him to find me 11,000 votes, and also with inciting people on January 6th to stop the steal, as he phrased it, and to interfere with the peaceful transition of power. And when it comes to finding guilt, the standard, in a criminal case is guilt beyond a reasonable doubt. There is no standard that is articulated for impeachment. As Gerald Ford once said, each senator is to decide by his own conscience whether he believes that this was the kind of offense for which a president should be impeached. And because President Trump is already out of office, he's been impeached, and the question is not removal from office, but whether he should be barred from ever seeking office again. I think he could also be convicted, which means he did this thing without that second vote of barring him from seeking office ever again. So it's fairly wide open what can happen. It is a political process and not the same as what we see in a criminal trial. And necessarily so, right? Because so many of the senators are direct witnesses. They were there that day. Some of them supported President Trump's goal of not certifying the election that day, like Senator Cruz and Senator Hawley. So it's very different from a criminal trial, but it is designed to hold accountable presidents for things that the public believes are abuses of his power.
Am I correct that the separate vote to bar future federal office is at a lower threshold? That's just a majority, as opposed to.
Oh, that's a good question, Dennis. I don't know the answer to that. Of course, to convict requires a vote of 2/3 of the Senate, and so I suppose if you had a conviction of 2/3, you could end up with fewer who then also want to vote to prevent him from holding office in the future. I don't know the answer to that, but that would be good to know.
And this issue of impeaching a non-sitting president, an ex-president, how do you take that one? And do you draw any inference from the fact that Chief Justice Roberts will not be the presiding judge at the impeachment trial?
So the president was impeached while he was still in office, and I don't think you can impeach people after they've left office. For example, I don't think you can impeach President Obama today or President Bush today. But he was impeached in December while he was still, or I guess it was early January, while he was still in office. It was in January, while he was still in office. So he was impeached. And then what it says is, in all cases of impeachment, the Senate shall hold a trial. And so I don't think there is anything that prevents the Senate from having the trial, even though his term has now expired. especially because there is this additional remedy that he can be barred from holding office in the future. So for any textualist or originalist who is saying that he can't be tried because he's left office, I think they're not reading the text. There's nothing in the text that would prevent that. And then the fact that Justice Roberts is not presiding, I don't think we should read anything into that. It says that when the president is tried for impeachment, the Chief Justice shall preside. The president is Joe Biden. And so we are now on the trial of a former president. And so I think it is not required that the Chief Justice preside. I don't know how it was chosen that he would not preside. He didn't seem very happy about presiding the last time when he had to by Constitution. And so he may be just as happy not to cross the street and participate this time around. But no, I don't think there is anything to be said about the validity of the proceeding because he's not there. The Constitution does not require his presence.
Robert Gruhl and others have asked about the integrity of future elections. And, we've had two exceedingly close elections in a row now. And 2020 was arguably on some measures even closer than 2016. In each case, the losing candidate has raised questions about the legitimacy of the winner. I mean, Hillary Clinton still talks about Russia having cost her the election and makes insinuation about collusion. And Trump has taken it to an entirely new level with his wild claims about voter fraud. We have a bitterly divided, closely divided electorate. Are we simply destined to have these kinds of, elections where the losing side walks away thinking they were robbed? And is there anything we can do to restore a broad consensus about the legitimacy of electoral outcomes?
I think we do have to be concerned about the ways that foreign adversaries can influence our elections. The Mueller report concluded that Russia interfered with a misinformation campaign. It wasn't that they changed the votes, it's that they were a presence on social media and actually organized rallies in communities in the United States. So that is an disinformation campaign. How do we get around that? I think public education is one way to do that, and also demanding more from our social media platforms about labeling that which is false information, or requiring people to at least open articles before they post them and forward them to others, because we saw that innocent people unwittingly spread a lot of misinformation in the 2016 campaign. This campaign, the concern was, I suppose, because of the large number of voting by mail, to see Trump have an early lead that then changed once those mail-in ballots were switched. For those who get their news from single sources, I suppose, maybe that looked suspicious. But of course, the explanation is that they count the votes by mail last. And so understandably, that changed when President Trump was urging his voters not to vote by mail and to vote in person. I think we can shore up our election integrity. I think in many states this time around, because of what happened in 2016, there was great care paid to avoiding hacks into our systems, having a paper trail of the way everybody voted, the ability to audit election results. All of those things are necessary, I think, into making sure people have confidence in the outcome of a vote. And then the way to challenge it is in our courts, where we did have a lot of challenges to the courts, and those upheld the ways the elections were done. So I think we need to constantly be vigilant about looking at ways that we are vulnerable to attack, whether through disinformation or hacking into systems. But I also think that we need responsible leaders. All of these laws and rules are administered by humans. And if humans are willing to lie to people and exploit those who are less informed, then I think we're going to have a problem. There's no foolproof guarantee against demagogues.
You touch on a subject that was also raised in the questions about misinformation in the political world. What is the government's proper role there, or possible role there? And also, if social media sites, Facebook, et cetera, or Twitter, exercise some kind of editorial discretion, or they risk losing their kind of special legal status what is the path forward there, if there is one that's at all
Yeah,
clear?
it's tricky. We have allowed Twitter and Facebook and others to become unregulated utilities. They control such an important flow of information, and yet they are on their own. We've allowed them to police themselves. I think because of increasing pressure in what's happened in our elections, we have seen Twitter now not permit political advertising and to put warnings up when there is potentially inaccurate information and direct readers to other sites to gain information, or ultimately blocking repeat offenders altogether, like President Trump. Facebook has taken a slightly different approach. They have standards, and they have their own. They call them the Facebook Oversight Board. Some people have referred to it as the Facebook Supreme Court. And reading their opinions was a little weird because it really had the feel of legal opinions. And these are not elected by the people. This is Facebook's own self-selected oversight board. And so I think at some point we will see more regulation in this space. I think that social media, even though it's been with us now for a while, is still a brand new phenomenon, and we're still getting our arms around all the ways it can be used and abused. It's certainly a fantastic tool. Like all technology, it can be used for good or evil. And I think we need to think about ways to harness it for its good and to prevent some of the evil. So it wouldn't surprise me to see more regulation going forward. I think one of the challenges is just keeping up with the technology. It evolves so quickly. And if you watch the hearings when people like Mark Zuckerberg and Jack Dorsey from Twitter come before members of Congress and they ask questions, it's quite clear to me that members of Congress aren't particularly adept with the technology. And it's challenging, I think, for them to keep up with that technology to guard against all the harms. You see this in surveillance laws as well. The law is often a generation behind where the technology is. And so that's a challenge as well. So I think the way to guard against it is coming up with some broad principles to protect against disinformation, perhaps some legal liability. But you don't want to lose the advantages of the social media platforms either, which is what that section 230 allows, that they're not really responsible for the content. We just operate the platform and, go ahead and say what you want to say. But I think that formula has not worked well. And so it wouldn't surprise me to see some increased regulation in the coming years.
While we're on the subject of speech and possible limitations on speech, a number of people have asked about hate speech and what status that has in respect to the First Amendment, and what rules or regulations can be applied there, criminal or otherwise.
Hate speech is very wide open and is very unregulated because of the First Amendment. When I was serving as U.S. Attorney here in the Eastern District of Michigan, we would frequently get complaints from people about really awful, hateful things that were appearing on social media. There are some laws against online harassment. And so if it is repeatedly directed at a particular individual, there are some state laws that protect that. There are some stalking laws that can protect people from that. But a lot of generalized things just about groups. We would get things targeted against police officers, against racial minorities, against immigrant groups, against the LGBT community. And much of that was too generalized to be what is known as a true threat. The Supreme Court had a case a few years ago involving Facebook. It's called Alanis. And in that case, it permitted a very wide swath for people to say very harmful, hateful, threatening things that they deem not to be a true threat. It has to be directed against an individual for specific harm or death to be a true threat. And so as a result, it is easy for many people to put really hateful things on social media. It can be very tricky. I read this book earlier this year called Active Measures by a man named Thomas Rid. And he talks about one of the challenges is that America is very vulnerable to exploitation by Russian intelligence because of our freedom, because we allow openness, because we allow people to say hateful things, we can be taken advantage of. And maybe that is just the cost of having free speech and democracy. But again, as we said earlier, the First Amendment is not without limitation. There are permissible limits as to time, place, and manner. And I think that we need to think thoughtfully and in a nuanced way about how we might want to regulate some of these things so that we can make the internet a place that is a safe community where people can say things and they're free to say things, but not things that are hurtful to other people.
Well, when you say hurtful, is the standard still, as I thought you were saying earlier, that there has to be a threat of physical harm or violence?
Yeah, well, by hurtful, I don't mean hurting your feelings.
Yes,
I mean,
physically.
people end up storming your home as a result. I mean, we've seen in Michigan, our Secretary of State had a huge crowd outside her personal private home, her family home, with people who had organized online to show up there with guns. At some point, somebody's going to get hurt doing that kind of thing. Storming the Capitol, much of that was organized on the social media app called Parler. And so when it becomes operational, that's when somebody's going to get hurt. And so I think we need to think carefully about what is permitted. Certainly planning an attack on social media is something that should not and cannot be permitted.
A number of people, Evan Betez and Margaret Kreitler, have asked about the Biden administration's plans for the judiciary. Margaret in particular asked if the Supreme Court might be expanded beyond its current 9 members.
Yeah, that was something that was getting a lot of talk before the election. I don't know where President Biden may land on that, but I think that we think of 9 Supreme Court justices as sort of sacrosanct because that's all most of us have ever known all our lives. But of course, in the history of the Supreme Court, it has actually had a variety of different makeups over time. And so adding to the number of justices in our larger and more complex country doesn't strike me as crazy or offensive. And so I think it's something that we could see. But I think another place where there is a bigger push, even by the court's own administrative office, is to expand the judiciary at the appellate court of appeals level. That's that in between. There are the district courts where we have trials. There's the Supreme Court that hears only about 80 cases a year when they're really interesting and novel cases of law. And in between are the courts of appeal, which have to hear every appeal. So every criminal case where they have a right to appeal, they hear them. Appeal from a district court, they have to hear them. They don't have the discretion that the Supreme Court has to say, we only have so much time and space and priorities, and these are the 80 or so we're going to hear this year. They have to hear all of them. And so they can tend to be overworked and overtaxed. That is a place where the courts would actually like more bodies. And I think that might be a way that Joe Biden could expand the judiciary by adding a few seats. Here in Michigan, we have the Sixth Circuit Court of Appeals. They're in Boston. You're in the First Circuit. So adding some First Circuit judges, I think, might help to move cases along more quickly.
There have been 9, I think, for 150 years. So while there were some juggling, I think, in the early part of the country's history, it's been stable for some time. And of course, there's the famous court packing attempt, or at least that President Roosevelt at least thought about. I don't think it really got all that far. But is there a risk in that of just a Democratic-controlled administration and Congress expands the judiciary to make, they wouldn't do that if they wouldn't support that if it was during a Republican administration. Is there an issue of politicizing the judiciary, which I think already is a matter of concern with many people?
Yes, and I think that's something you have to think about the court's legitimacy because, you have to take the long view in these things. Even 150 years, I don't think is a long enough view. And could we foresee a future where when you have a Democratic president and a Democratic Senate and House, you decide to add, I don't know what, 3 seats, 4 seats to the Supreme Court. And then in a few years, we have a situation where Republicans control all 3 and they add 4 seats. And then, before you know it, we have 100 people on our Supreme Court. Does that risk losing its legitimacy? And I think that is a real risk that has to be considered. I think one of the real harms of the past 4 years is an erosion of the concept of an independent judiciary. President Trump is fond of referring to people as Obama judges or Trump judges or Bush judges or Clinton judges. And I think that's really harmful. Until then, I don't think there was much thought given to who appointed a particular judge on the bench. And I think that when we think of them as being aligned with political parties, it undermines public confidence in their decisions, which I think can erode trust in the rule of law and compliance with the rule of law. If everybody thinks the judge is just a political hack, I think they're less likely to obey the law. And that is not a good trend for our country. And so I agree with you that I think anything that contributes to that politicization of the judiciary is not a good thing. And that would be a reason to be cautious about that.
Have the confirmation hearings contributed to that? They've become obviously very, animated. And I believe of Trump's 3 Supreme Court appointments, I don't think altogether, I think not only Gorsuch, I think received any Democratic support. And I think it was only 3 senators. Now there's the Merrick Garland background to that, I know, but hearings themselves the senators seem to think that there are Democrat and Republican judges. Does that not feed to the general population?
Yes, I mean, certainly there are judges and justices who are appointed by presidents, in part because I think they believe that they have a worldview that will advance their political agenda. But once they're confirmed to the court, there is value in these lifetime appointments. There are justices who have been appointed by Republican presidents who've ended up being quite liberal. We had Justice Souter was appointed by President Bush 41 and ended up being quite liberal. I think Justice Stevens was one who was appointed by President Nixon and ended up becoming quite liberal. And so there is, I think, still that life tenure gives people that value.
Stevens, I think, wasn't he Ford?
Was he Ford, a Republican?
I think Ford said it was one of his proudest appointments.
And he is one who ended up becoming quite liberal. I know that when
William Brennan,
when Chief Justice Roberts ruled in favor of the Affordable Care Act, there was a lot of outcry that he had betrayed the president who had appointed him. And I think that is just the wrong way to think about it. He's appointed by a particular president who may hope that that justice or judge reflects his worldview, but that should not dictate the outcome in any particular case. And so Justice Roberts should be looking at things like the Affordable Care Act on the facts and law and making the decision that he thinks is correct. I think it's not a surprise that people tend to reflect the values of the president who appointed them. That is why they were chosen, for their judicial philosophy and their outlook, but not because they expected them to line up with their views on every single case. But yes, I think televised confirmation hearings contributes to that idea of politics. The Senate is a political body, and I think they do look for opportunities to score political points, even if they don't affect the outcome of the vote on the candidate. I think they see it as their opportunity to score their own political points and demonstrate to their voters their values. And so I think as a result of televising judicial hearings, it has contributed to this kind of political component of the confirmation process.
We got a live question from Scott S. I don't know his last name, but he's raising the possibility of term limits, which off of what you just said, you think might not be a good idea. Should I take that?
Yeah, I've seen that before, and that's the idea that you can't, that way you would avoid, President Trump got to put 3 justices on the Supreme Court, and they're fairly young. He will influence that court for 30 years between Justices Gorsuch, Kavanaugh, and Coney Barrett. They'll be there for 30 years. And do we want to give one president just sort of by dumb luck so much power in influencing the next couple of generations?
Emphasis on the dumb.
And there are other presidents who, get 1 or none. Term limits would make sure that you have a little bit of a turnover. I'm not sure I agree with that would help because there still is an awful lot of luck in who ends up replacing them, right? If they're up in 18 years, who knows which president will be in power at that time. So I guess it gives more frequent opportunities for turnover on the bench. People aren't going to stay for 30 years. They might stay, I know I've seen 18 years, 12 years as a term, but I do think there's value in this idea of life tenure because no one on the bench has to ever think about what will be my next job. And it removes any sort of conflict of interest where they have to be thinking about, well, I want to please the business community because I'm going to want a job in business, or I need to please whatever group it is, Republicans or Democrats or academia, whatever it is, because that's where I want my next job to be. And so I think that life tenure is really a brilliant idea that builds in independence, where judges and justices can say, I don't really care what people think of this. This is what I think is right. So I think I wouldn't favor that. But there is an argument to be had that it means that people don't lock up seats on the court for 30 years, or, I think William Douglas was on for 40 years, longest serving. And so it is a way to have more diverse viewpoints, I suppose, on the court by changing up the seats more frequently.
Another question we got from a few people concerns the department well, the Justice Department, and what's the future there. There's now become kind of a tradition with each administration for its opponents, the opposite party, to say that it's been politicized. AG Barr got very sharp criticism from Democrats for being too close to President Trump. Eric Holder got some of the same while he was AG, and he had famously said he was President Obama's wingman, which I'm not sure is a remark he is pleased to have made. But what is your view of the right standard there, and who would you offer as a role model of someone who really lived up to that standard?
I think that when you're in the Justice Department, you have to be very careful about not only being fair and impartial and independent, but also conveying the perception that you are fair and impartial and independent. I didn't see anything that Eric Holder did that was anything other than independent, but I think using that phrase was probably a poor choice of words that he would regret because it suggested to the public that he was there to do the bidding of President Obama. With William Barr, I thought he did damage the integrity of the Justice Department in a few ways. He, during the time that President Trump was contesting the vote count, he changed the policy at the Justice Department about overtly investigating things that might influence the outcome of an election. He moved to dismiss charges against Michael Flynn for false statements to the FBI under a very tortured analysis of materiality. He weighed in on the sentencing of Roger Stone to withdraw the pleading of the career prosecutors and replace it by one that sought leniency. And he didn't weigh in other cases, only those where there was a defendant who was an ally of the president. Again, he may have thought all those things were the right thing to do, but you have to be cognizant not only of actual impartiality, but the appearance of impartiality. And I think he failed miserably in that regard. I think the next administration has work to do to repair that perception that the Justice Department is just one more political part of the machinery of a presidential administration. It has to be the least political part of a presidential administration. And I think that some things need to be done to go out of the way to do that. I think a good example of that is Edward Levy, who was the Attorney General for Jimmy Carter following Watergate. And he did a lot of things to talk about and instill integrity in the Justice Department, including public speaking about the importance of the independence of the Justice Department, putting in place a lot of the norms and policies we see today about not investigating elections close to an election for fear that there will be some influence on that. And so I think we need to do those things. Another is that he implemented is communications between the White House and the Justice Department, that there should be no communication about individual cases between the White House. You can talk about priorities. It's going to be my priority to enforce civil rights laws, or I want it to be a priority to go after opioids and not marijuana. That's all fine. But when it comes to individual cases, the White House needs to stay out of that so that the Justice Department can decide cases based on facts and law.
You're forgetting again about our alum, Gerald Ford. I think Levy was his AG. Wasn't Griffin Bell Carter's AG?
Perhaps you're right, Dennis. Thank you for that correction.
We're
belying our ages.
He was an alum with on the football team. We've got to do our best to protect his reputation.
Thank you.
Yeah. One of the questions we did get that has some, I think, current significance before the Supreme Court is about the Affordable Care Act. And part of the legacy of Justice Roberts' decision or contribution to the majority that upheld the act was this view that, it was a tax. And when the penalty was removed from the legislation, there was an argument made, which I'm curious to hear what you think about, that then brought you back under relying on the Commerce Clause as your authority, and that there was a 5-4 majority with Justice Roberts saying the Commerce Clause did not give the federal government that authority. So that case, I think, is now before the court. Any view on how that comes out?
No, that's not really my area of expertise. I know Nick Bagley of our law school has opined on that, and is of the view that you can sever parts of a statute to save it. And that has been his view. He is someone who has studied administrative law. But other than that, my area of expertise really is in the criminal law and criminal procedures. So I can't really opine on that. But I look forward to seeing that one when it's argued and comes out.
We did get a number of questions, and you alluded to it a bit in your opening remarks about the role of the police. The unfortunate, whole series of events in which police have been involved in shootings of minority population. What can be done there? We've gotten a question about civilian review boards, and is that a tool for appropriate regulation? How do those work? You probably had some experience with this in your time at the U.S. Attorney's Office.
Yes, in fact, when I was in the U.S. Attorney's Office, we did a consent decree with the Detroit Police Department. They had a series of problems, including use of excessive force and the killing of unarmed civilians, as well as a number of other aspects of unconstitutional policing. And we went through a large review and some changes. And one of them was to have a civilian oversight board. Sometimes I think that when police are policing themselves, they may have different standards than the public would expect. It also, I think, brings with it some public confidence that there is civilian oversight of policing, so that you don't have that perception that there's that thin blue line of police officers protecting themselves against others. So I do think it is one way to address police misconduct. There is a whole series of proposals that were posited during the Obama administration in his task force on 21st century policing. And I am hopeful that President Biden will take that baton and continue that work by breathing some life into it. That brought with it a number of recommendations, but we haven't really seen the implementation of those recommendations. And I'm hopeful that we'll see that. Some of them relate to training, helping police officers deal with situations that can escalate quickly. It includes implicit bias and not jumping to conclusions or panicking based on who it is that we're dealing with. It also includes how to deal with mentally ill individuals, which contributes to a huge amount of police violence when people do not obey verbal commands of police officers. It understandably escalates tensions and can sometimes lead to violence. And sometimes police officers don't have that training. And another thing that's been really unaddressed that's included in that report is officer wellness. So many police officers experience trauma, whether it is being the first to the scene of a fatal car accident, or showing up at a home where a child has been sexually abused, or a horrific murder scene. And then they're supposed to just show up to work the next day. It's not surprising that sometimes police officers are dealing with post-traumatic stress disorders that they're not getting addressed. And so I think helping police officers deal with some of those things can help them from panicking when they end up in a situation that calls for calmness. So it's a lot of work to be done in policing. And again, that brings me back to this thought about nuance. We can't find ourselves being for or against policing. It's here to stay. We need it. And so how can we do it better? We can do better, and let's all work toward that solution.
Yeah, it's a tough job, but it does need to be done better. I think maybe time for one more question, unless I see a live one. I don't. A number of people were interested in whether you'd see in the Biden administration a more aggressive approach to housing discrimination, which I think they believe may not have been properly prioritized in the Trump administration.
Yeah, I don't know what the focus of the Civil Rights Division will be, but housing is certainly a component of it, and is one that needs a lot of work. When I became U.S. Attorney, I set up a civil rights unit, and we did a fair amount of fair housing work. And I was surprised to find out how much discrimination there was in housing. I mean, right here in Ann Arbor, we brought a case against an apartment complex that was discriminating against Black would-be tenants. And DOJ has a really interesting program for fair housing. It's called its testing program. And it takes volunteers from all over the country who are DOJ employees. Some of our people went to do this, and they'll send you to a different city where no one knows you. But one of the things that we did in this Ann Arbor housing situation was, after we got complaints from a number of Black would-be tenants who were denied apartments, after they saw a sign saying, you know, vacancies, apartments available, they would go in to inquire and be told, oh, you know, we just rented that apartment, sorry, not there anymore. So we sent in pairs of identically situated undercover would-be prospective tenants, and they would be identical in every way except their race. They would have similar job descriptions, employment, income, so that on paper, you know, there was no real distinction between them. Sent in 40 pairs, and 40 out of 40, the white prospective tenant was shown the apartment, and the Black prospective tenant was turned away every time. And so we brought a lawsuit against him, which was quickly settled. There are cases like that all over the country. And so I am hopeful that we'll see robust enforcement, because what happens when you enforce one of those is not only do you get damages for the person who is the victim of that, but they have to change their policy and undergo training and be educated about the law and stop doing that. So it can have exponential rewards when you bring those kinds of cases. So I'm hopeful that this Department of Justice will do that.
Well, Barb, thanks so much. This has been a real pleasure. And I know the audience has appreciated, you know, your insightful remarks. And I have to say, beyond that, I think the law school is very lucky to have you on the faculty and bringing, you know, your deep experience and the benefit of that experience to the students.
Well, thanks very much, Dennis. I appreciate your work as our moderator here. Nice chatting with you. Thank you to all of our folks in the Boston area who were joining. I'm sorry we didn't get to all of the questions.
Yeah.
And Anne, thank you. And we'll turn it back to you.
Yes, Anne.
Back to you. Thanks to both of you. And I don't know if you can hang on for one more minute, Professor McQuade. There was a question about the pins on your board behind you. What's the story there?
Sure. So these are law enforcement pins. When I was in the U.S. Attorney's Office, they're lapel pins. So people from the FBI or the Secret Service would wear them. And then exchanging and trading pins became a thing. So we had our own at the U.S. Attorney's Office, funded by me and not our taxpayers. And it became a thing to sort of trade them within law enforcement. So over the years, I've collected them, and those are what appear on the board there.
Thank you for that. That's just a really fun personal anecdote. Appreciate that. So thanks to you, Dennis. Thank you so much for leading us. This has been just a really rewarding and interesting conversation. There were a lot of questions. Really sorry that we couldn't get to all of them. We probably could have been chatting for 3 hours and not gotten to all of them, but really a terrific program today. And I really never tire of being in the company of such accomplished and interesting and passionate alums like the two of you. So for our guests today, please be on the lookout for a follow-up email. There will be a survey asking about today's program and future programs that you may be interested in. And should you want to get in touch with me and you don't already have my contact information, it will be included. So thanks again, both to you, Barb and Dennis. And as always, go blue.